Yeah, you know what time it is. Disclaimer, I am not an attorney, nor do I offer or give legal advice. So please understand that all information that we talk about in any of my webinars are strictly information and educational purposes. And most of it is just personal experiences with things anyway. So please understand this is not legal advice. And may you be blessed on your journey to find your power within these laws. Peace and blessings. All right, what we have here now is the Federal Trade Commission staff guidelines on trade regulations rules concerning preservation of consumers' claims and defenses. Holder in due course rule. This is the Bureau of Consumer Protection, Washington, D.C. All right, let's check this out. Table of contents, the preface, text of the rule, the purpose of the rule, the mechanism of the rule, credit contracts which must contain the notice, so that affected transactions, financing and sale, purchase money loans, general consideration, specific purpose, relation between creditor and the seller, referrals, affiliation, placement of the notice, effective date, proposed. Okay, so let's get in here. I'm moving too fast there, my apologies. All right. Now, I've already went through and highlighted some key things that we're going to dwell on because I just want to bring this to your attention so you can go down and actually go in and start reading this stuff. But right here, this is a seller's correspondent duty to keep his promise. All right. Now, the seller has a duty as well. We often deal with these corporations as if we're the only one that is supposed to be performing. No, performance goes from both parties. All right. Typically, the circumstances are as follows. A consumer relying in good faith on what the seller has represented to be a product's characteristics, service, warranty, etc., makes a purchase on credit terms. The consumer then finds the product unsatisfactory. It fails to measure up to the claim made on its behalf by the seller, or the seller refuses to provide promised maintenance. All right? So there was already issues about sellers not performing way back in the day. So all right, and this is where this came about. On November 14, 1975, the Federal Trade Commission addressed this problem by promulgating a final trade regulation rule concerning the preservation of consumers' claims and defenses. The rule, also sometimes called the Holder in Due Course Rule, becomes effective on May 14, 1976. All right. They got the text of the rule. Now, right here, go straight into what? Definitions. All right? Definitions. This is very important. We'll be surprised what we find in these definitions because we often go into these situations assuming that we already know what everything is. A person is an individual, corporation, or any other business. A consumer, a natural person who seeks or acquires goods or services for personal, family, or household use. Creditor, a person who, in the ordinary course of business, lends purchase money or finances the sale of goods or services to consumers on deferred payment basis, provided such person is not acting for the purpose of a particular transaction in the capacity of a credit card issuer. All right, purchase money loan, a cash advance, which, a cash advance is a purchase money loan, which is received by a consumer in return for a finance charge. What? So when we go and hear that term finance charge, they're going to finance charge the vehicle. We are supposed to receive a what? Cash advance? Is that the loan? Purchase money loan? Now we are getting somewhere, right? Which is received by a consumer in return for a finance charge within the meaning of the Truth in Lending Act and Regulation Z. Let's jump up here real quick. Consumer credit contract. Any instrument which evidences or embodies a debt arising from a Purchase money loan. What? Transactions or a finance sale as defined in paragraph D and E. Jump up here to E. Let's go on and highlight that one. Boom. Financing a sale, extending credit to a consumer in connection with a credit sale within the meaning of the Truth in Lending Act. Wow. So now we know what the loan is. So a loan, where is the cash advance? Interesting. All right, let's keep reading. 433.2. This is a subsection. Preservation of consumers' claims and defenses, unfair or deceptive acts or practices in connection with any sale or lease of goods or services to consumers in or affecting commerce as commerce is defined in the Federal Trade Commission Act. It is an unfair or deceptive act or practice within the meaning of Section 5 of that act for a seller directly or indirectly to A. Take or receive a consumer credit contract which fails to contain the following provision in at least a 10-point bold-faced type. Notice here, the notice. Any holder of this consumer credit contract is subject to all claims and defenses which the debtor could assert against the seller of goods or services obtained pursuant hereto, or with the proceeds hereof. Recovery hereunder by the debtor shall not exceed amounts paid by the debtor hereunder. All right. So that's the notice that is required to be on the document. Now, if you've seen the previous part of the video where I showed you on the contract, that notice was on the document, right? Let's go back to the dot. Boom. Here go that notice. But there was something above it right here. The following notice only applies. So they said that this doesn't apply. Let's go back to what the FTC said. Purpose of the rule. Okay, in adopting this rule, the commission determined that it constitutes an unfair and deceptive practice within the meaning of Section 5 of the FTC Commission Act, 15 U.S.C. 45, for a seller in the course of financing a consumer purchase of goods or services to employ procedures which makes the consumer's duty to pay independent of the seller's duty to fulfill his obligation, right? They wanted me to pay. They constantly was talking in that contract about what I'm obligated to do, but they never clarified what they were supposed to do, right? So here we go. So this whole purpose of this notice is for situations like this. But if we don't read, we never know what is in store for us to fight these corporations. Case in point. Back up a little bit. Under ordinary contract law, the promise of the parties to a sale transaction are mutually dependent, y'all. Mutually dependent. Mutually. That means both parties must perform. A seller is entitled to payments provided he delivers what he promised to deliver. Where is the loan, y'all? Where is that cash advance? If the seller fails to deliver what was promised, the consumer's obligation to pay may be reduced or even eliminated. However, it is possible for a seller to arrange credit terms for buyers which separate the consumer's legal duty to pay from the seller's legal duty to keep his promise. Now, we just heard what that was said. I don't even need to say nothing else about it. I'm just gonna keep on moving. You can go back and ponder on that on your own time. Mechanism of the rule. Now, We already see the notice. We're not going to go into all of this. Like I said, we're going to do that for your own time, but we're going to look at what I highlighted already. For this reason, where use of the notice is required, the notice must appear without qualification. Let's read that again. For this reason, where the use of the notice is required, the notice must not appear without qualification. Without qualification. Without qualification. Without qualification. This notice must appear. Okay. The requirement that a contract contain the notice is not satisfied if the text of the notice is printed in the contract in conjunction with additional recital which limit or restrict its application. Limits or restricts its application. Where the text of the notice is qualified by additional language, the contract fails to contain the required notice. So, looks like they failed here. What do y'all think? FTC says they failed. So, let's keep going a little bit more. Let's see. Like I said, I'm not going to read most of it, okay? Because you get the point. I read what's important to understand from this. The intent of this rule is to define as purchase money loans those consumer loans made for the acquisition of goods or services from a particular seller and consummated under circumstances where a seller and a lender have an established relationship or course of dealing with one another, which is directed at financing sales. In such cases, and only in such cases, the rule requires the seller to ensure that the consumer's loan contract contains the notice. So, we have them being in violation of not having this notice. So by them being such violation, let me show you what else we can dig up. All right, we got right here. So, in other words, the consumer may assert by way of claim or defense a right not to pay all or part of the outstanding balance owed the creditor under the contract, but the consumer will not be entitled to receive from the creditor an affirmative recovery which exceeds the amounts of money the consumer has paid in. Okay, so we can get the money we've paid in. We can't get more back than what we've paid in, but at the same time, we can also get that outstanding balance wiped out. Right? Isn't that what it say? Right not to pay all or part of the outstanding balance owed the creditor under this contract. So this may be your way out of your contract. So go ahead, pull out your contract on your vehicle and see if this rule applies to you. Peace and prosperity.